many of those outside of the system just don't even have a way of evaluating how well is it working for me, other than being able to say, hey, it's not, but they can't really give a lot of feedback. And they can't go somewhere else. I mean, you can go to a different law firm, but you can't say, I don't want this legal system you created. I want a different kind of legal system.
Today on LawNext, I'll speak with Gillian Hadfield, professor of law and economics, currently based at the University of Toronto, and someone who has focused much of her career in scholarship on legal innovation and access to justice. We'll talk about her 2016 book, Rules for a Flat World, Why Humans Invented Law and How to Reinvent It for a Complex Global Economy, as well as her recent research on ensuring the safety of artificial intelligence. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support LawNext. And now, on to this week's interview. Gillian Hadfield, welcome to LawNext.
Oh, it's great to be here with you, Bob.
Appreciate your taking the time to be with us today. I want to start by just asking, I know that a lot of your research and writing in recent years has focused on issues around legal innovation and access to justice. And I'm curious what led you to want to focus on those areas.
Well, there's two answers to that question. There's the purely scholarly one, which is that from the beginning of my work in law and economics as a graduate student at Stanford, I was always interested in, the design of institutions and how, what are the design? How are legal systems designed? Why do they look the way that they do? But there's a personal part of that as well, which is I was involved in family custody litigation early in my life, and it gave me the experience of what it's like to actually be inside of these institutions, to be on the receiving end of how our courts are working and our legal systems and legal reasoning works. And I never wanted to write about or talk very much professionally, of course, about my personal life, but I felt a real responsibility to try and understand why it looked the way that it did. Why on earth was it so expensive? Why was it not seeming to come up with good solutions to what really was a fairly ordinary event, which is people do get divorced? And I felt a responsibility as an economist and a law professor to say, I should be thinking about these questions. So I started thinking about it's kind of a strange example, really, the 1993 World Trade Center bombing case, which was in the news at the time because it was taking 15 years. It took 15 years to get to a jury, and seemed an example of, here's a setting where why is this system not working better? And I've just kind of followed a path from there. It took me into the 9/11 case, the September 11th Victim Compensation Fund. At some point, I started interviewing general counsel at large global corporations like Mark Chandler at Cisco and Kent Walker, and something that sounded very much like what I mean in my experiences. It's too expensive. It's not solving our problems. We need to find other ways to do this. So there is a personal odyssey that's part of it, but it's been very motivated by this framework of saying we really need to think about how we design these institutions and markets.
It's interesting to me that I hadn't been aware of that coincided with thinking about 9/11 because, of course, what came out of 9/11 was that victims' compensation fund led by Ken Feinberg, or overseen by Ken Feinberg, and which it was kind of an alternative to. Not kind of, it was an alternative to handling these claims through the traditional legal route. And it's something you've written quite a bit about is developing alternatives to the sort of the traditional legal process or legal system as it stands now.
Right. Well, yes, you're exactly right. The 9/11 Victim Compensation Fund was set up precisely to find an alternative. The message from lawyers and judges was, don't have anything to do with the legal system. The courts won't provide you with an answer. All they can give you is money, and it will take years, and it will be awful, and it will be expensive. Let's find a solution to get out of that system. And, that can be one answer, but I was really struck by, instead of saying, why are we not fixing that system so that it actually can perform that function in a more reasonable, timely, cost-effective, responsive way? It was like hearing judges and lawyers say, oh, this thing we've built, nobody wants to go anywhere near that. Let's create this entirely separate thing, give one person an unlimited budget. And I think Ken Feinberg did a pretty good job. But let's give one single person an unlimited budget, and he will then determine how to hand out money. One of the things I did in that work was to interview and survey families of victims who were entitled to claim with the fund. And one of the things, of course, they had to do was sign a release to say that they would not sue anybody. That included, Port Authority or airlines. And I was interested in a very simple question. What did they feel they were giving up in going to this system that was clearly going to give them more money sooner than the legal system and the courts? And the answers were really very striking and emphasize why we need to fix our existing systems and not just divert people out of them. And that was, it was a public forum for an adjudication of potential wrongdoing. It was a way to feel that you had done something in response. You'd had some impact on this won't happen again. And was a way of gaining access to information and accounts that you otherwise have no way of getting. And they had to give up all of that. And so it really crystallized for me that we need to be thinking about how to fix our systems and not just giving up on them, which is what the 9/11 Victim Compensation Fund was doing.
So in your book, which is Rules for a Flat World, Why Humans Invented Law and How to Reinvent It for a Complex Legal Economy, you pick up from Thomas Friedman's 2005 bestseller, The World is Flat, and suggest that in the years since Friedman's book, the world has gotten even flatter, thanks largely to digitization on a global scale. But you argue in the book that even as the pace of change has continued to accelerate, the legal infrastructure, our legal infrastructure, is not up to the task of managing it all. There's a quote out of your book. You wrote, "The legal systems we have are failing ever more regularly to do what law is supposed to do, make it easier for people to work together and make life for all better, not worse." So what are the fundamental flaws in our legal structures? How is it that they're not up to the challenges of the flat world?
Well, I mean, we can look across several domains. You can listen to the people that are having to deal with the legal system, need the legal system. You can listen to those people, are sort of on the access to justice side and the experiences of ordinary people going through a very complex, inscrutable system to try and resolve ordinary issues. But as I indicated, the real source of getting an idea about this was talking to general counsel at large global corporations. And what they were telling me is, we all hear about cost. It's too expensive. But of course, these are the companies that have pretty substantial legal budgets, and money can be well spent. And what they were telling me was they weren't able to buy the kind of legal services that they needed to make business decisions about how to handle complex environments, how to navigate a complex risk environment. They would complain, for example, that lawyers, would come in, even very high-end lawyers would come in and, be really good at spotting risks, but not necessarily very good at helping to prioritize and navigate, anticipate those risks, to design innovative solutions to them. remember talking to Ramzi Hamsani when he was an assistant or associate general counsel at Google at the time, and he had overseen the acquisition and rollout of YouTube. And he sort of said, "Look, here we are. We've got this service. We're rolling it out in 100 countries all at once. There are complex legal environments in all those 100 places, and we really couldn't find anybody." Out in the legal market who could help us come up with strategies and plans and designs and structures to manage that many different locations. It was like, well, you have to talk to lawyers at each of those different locations. And, he said we had to really come up with our own solutions internally, in-house in the legal department. And that was okay, but it wasn't really what they wanted to do. They would rather have purchased that assistance from experts outside who had done more than one of them or done things like it. And so it was really striking. Here are, well-funded, high-end corporations that are saying we need this kind of service, and we just can't find it. So I think it's a combination of cost is a problem, but it's the responsiveness. It's do you understand my problem? Do you understand the kinds of things I'm dealing with, that I don't want a 50-page memo? I want 5 bullet points tomorrow that I can, read as I'm getting out of the cab in China.
We'll get back to my interview in just a moment. But first, let's take a break to hear from the sponsors who generously support LawNext. And now let's continue this week's interview. You talk about the legal infrastructure as opposed to legal systems, which I think is a kind of a broader term that involves not just the sort of the established players and institutions of the legal system, but the clients and the economy and everything else that kind of surrounds the legal system. You can define it better than I can, but I mean, it sounds to me that you're saying that the problem right now is it's not working for anybody. It's not working for those low income people or those people in family court or even the most, the biggest corporations with the most money.
Yeah. No, and I think that's why it's the book, says, let's really look at this in the whole arc of the building, the ways in which humans have built the platforms of rules on which they build their societies. That platform that I ultimately call our legal infrastructure is the basis on which we all have confidence and we move together in a complex world, and we expect that the restaurant is serving, food that's been prepared in sanitary conditions, and the company has built, the the construction company has built the building so it will stand up, and so on. We're building these things. We build on top of this set of rules, and the concept of legal infrastructure here is to say, what does that full set look like? How much does it cost? What do people know? What kind of solutions do the legal experts that you go to speak to provide? And this is, again, across the board, from the people who can't afford it at all because it's too expensive. So we have 90%, I always think it's about 90% of the population really can't afford the kind of legal help that they need. If you include not just representation in courts for family matters or evictions or collections, but also, a review of a mortgage or review of a summons or something like that, documents. So all the way from those people it's so expensive they can't afford it, to the companies that can afford lots of it, who actually account for, 75 to 80% of the revenues earned by law firms are earned by those top 8% of law firms that serve those big companies. And what they're saying is, it's not helping me solve my problem. It's not responding to my need. And so that says to me, there's something wrong with just at the heart of how we're producing that legal infrastructure. We've produced systems and structures that are too expensive and not relative enough to what people need from it.
Well, and it seems that as both a legal scholar and an economist, you've kind of looked at this in your book and suggested that the way that gets fixed is through in a way, ceding greater control to the market in general. Maybe that's not the right way to put it, but you argue that certainly lawyers and the kind of existing top-down structure that we have now that kind of drives the legal system now is probably not the way this is going to get fixed. Is that fair to say?
Yeah, it's important to remember. So I think, lawyers are, smart, creative, hardworking. This is not a problem with the people who are lawyers. It's a problem with the structures in which they operate. And so if you look at a system that isn't responding to overwhelming demand for help, for work, and you say, why is it not producing that? And this is why it's really important to notice it's not responding well for the high end, those with lots of resources. And so, you look at the statistics that, I think there was a study, this is actually going back to even before the crash, 2006, and it hasn't fixed since then, I'm pretty sure. 70% of GCs saying they wouldn't recommend their primary law firm, 80% having reduced work to outside firms in the past couple of years, and most of them, 88%, saying because of problems in quality and responsiveness. So you look at that, and that data has just continued. We know that since the crash, demand for even the high-end law firm work has basically stayed flat. So here you have well-funded corporations saying, we really need something. And you have to ask yourself, why does that system not respond to that? Why does it not say, hey, there's the market saying, please give me something. I'm willing to pay lots of money for it. Why is the supply side not meeting that demand? And to my mind, that's because it's a very closed system. It's cut off from the essential ingredients that lead markets and organizations to respond to demand. So what do we have in law? We have a closed system in which, because of our rules about who may provide legal goods and services, what we call our unauthorized practice rules, everybody who participates on the supply side in this market had the same training. They've all done a law degree. They've all passed a bar. They're subject to rules of professional conduct. So number one, we've just brought a whole bunch of people who could be highly diverse. They're in fact not tremendously diverse when we bring them in, but they're certainly more diverse than they end up. And we've homogenized. We said everybody's going to have the same kind of training, the same ethical orientations, value orientation, and the same framing, same way of slicing up problems. Then we're going to stick them in work environments where pretty much everybody else around them is also a lawyer. So most lawyers are working in law firms that, again, according to, as a matter of our rules of professional regulation, that are, law firms that are owned, managed, financed by lawyers. So just about everybody you see in there is a lawyer. That's changing a little bit in our bigger firms, but it's still, the governance structure is lawyers, or legal departments that are historically lawyers, more non-lawyers showing up there. And then we go into courts where pretty much all the participants, who are running the show are lawyers, and it's kind of lawyers everywhere. So everybody looks the same. And that cuts you off from a critical source of innovation, which is diversity of ideas and thinking and thought. I like to say it's a homogeneous idea pool. We really kind of all got the same way of slicing it up. Then you add to that the fact that it's pretty mystifying to everybody who's outside of that system. We've created a pretty complex system. You need this high level of training to have access to it. And many of those outside of the system just don't even have a way of evaluating how well is it working for me, other than being able to say, hey, it's not, but they can't really give a lot of feedback. And they can't go somewhere else. I mean, you can go to a different law firm, but you can't say, I don't want this legal system you've created. I
Right.
want a different kind of legal system. There's no
Right.
competing system to go to. So I think all of this adds up to we also cut ourselves off from venture capital because you can't have access to the capital markets to finance legal innovation. We cut ourselves off from the kinds of collaborations you see everywhere else in the economy with profit sharing and revenue sharing arrangements that create incentives for technology companies and other kinds of professionals and business experts and so on to build better systems or delivery modes. We've just cut ourselves off from all the basic tools we use throughout the rest of the economy to be innovative, productive, and adaptive, and really locked ourselves into business models that just turn out more of the same. And that's what's not working.
Yeah. How does that lack of venture capital inhibit innovation? I mean, there is plenty of capital within the legal market. I mean, look at a firm like Baker or McKenzie or any number of large firms. They've got plenty of money to throw around if they wanted to. I mean, why isn't that they can't be more innovative, within the system as it now stands?
So you can have lots of money lying around and it's not all that's available for being invested in risky enterprises. Innovation is risky, right? You have to be willing to put money on the line on a lot of bets for coming up with a new way of solving a problem. That's why, venture capitalists are looking for a substantial return on their investment because they know a whole bunch of these bets will not pay off. So they're looking for the ones that, if they do pay off, they pay off big. Having lots of money around at the end of the year in a law firm, and I haven't ever been inside a law firm, but here's what I think is happening. There's a lot of money around at the end of, the fiscal year, and partners are saying, okay, let's divide it up. Most of that is getting rolled into payments. And it's very hard to get that kind of a structure, a partnership, which is this, you can't tie lawyers tightly to the firm. You can't require that the business that's created within the firm by the firm belong to the firm. Because if the partner leaves with the book of business, in fact, another one of our professional regulation rules says that that the clients have to be able to go with the lawyer. So you've got a structure where you haven't got the kind of entity that says, okay, we've decided to make a bet on building a kind of technology nobody's built before and a delivery model nobody's seen before. And it may take us 2, 3, 4, 5 years to see that work out, for that to start, paying off. Think about, a lot of our dramatic startups in other technology areas. It takes them a long time to show a profit. The partnership model, even if it's got a lot of money floating around, does not support that kind of investment. It's not risk-taking in that way. I mean, it doesn't make sense for an individual to risk their own salary, basically, on high-risk investments. It doesn't make sense. You can't guarantee that the payoff to the investment redounds back to the firm. And that's what we see. We do not see this kind of behavior out of our partnerships, even if they're organized as professional corporations. And I say, just flip over and take a look at our other, corporations and entities in the economy. Google is not a set of partners. Apple is not a set of partners. It's an entity that recoups the benefit of its investments, and has the capacity to sustain those investments over the kind of framework that you have to be able to see return. You can't. I saw a great quote. Bob, you may even be somebody who put it up on Twitter. Was somebody saying, a lawyer saying, "I've got this great idea," and somebody says, "Yeah, you'll make 10 million on that, but it'll cost you 150,000 to do." He says, "What? I can't do that if I don't know it's going to pay off." And I just thought that that kind of captures truth here and that makes sense. This is not a criticism of lawyers.
Right.
It makes no sense for individuals to take these kind of bets.
Yeah.
You need aggregate of capital to do that.
Yeah. But it is a criticism of the regulatory environment in which lawyers operate. And is altering that regulatory environment the key to sparking more competition and innovation?
I absolutely believe that it is. It's a necessary change that we have to make in order to to open up this market so that it can be more responsive, so that we can get more diversity of ideas and energy and incentives and capital. I don't think you can do it without it. And I think all the evidence is there. I mean, I've been talking about the regulatory environment as the barrier for, I guess, about 15 years now, looking at the problems in the big firm market, saying, no, eventually the market will respond and will produce it. And I think there's a lot of people who are looking 10 years down the road and saying, how come we haven't done this yet? And I think there's a recognition that it's about these rules, because again, you just go through the litany of you can't share profits and revenues with somebody who's not a licensed lawyer. Well, we call that in the legal profession, we call that the evil thing of fee splitting. And the rest of the world calls that profit and revenue sharing and incentive contracts and risk sharing contracts. That's the lifeblood of the organization of economic economic entities. It's the lifeblood of innovation. If you don't figure out how to shift around the risk to the best place and how to create incentives for the people who have additional things to add to your problem, you can't produce creative things. And that's what we see. So you add that, and then you say, and you can't have corporate entities. Well, that means you can't get scale. You can't get the kind of scale you need to sustain the kinds of investment. I have heard very many lawyers over the years say to me, people with a lot of knowledge and motivation to see things change will say, well, you don't need a lot of capital in law. It's not really a capital intensive activity. And I think, yeah, our traditional model is, number one, it's not capital intensive other than human capital, but we should be more capital intensive. There should be more solutions that are available through the technologies we now recognize, things like artificial intelligence and blockchain and smart contracts and lots of things we could be doing with technology. And the second is to recognize the really important part about capital is capital to fund failure. You need the capital that can withstand, we tried this, we didn't hit it until the fifth or the sixth try or the 10th try. And our professional regulation rules say we can't do that.
There are, of course, there is some activity in the United States around this. California is looking at the issue following Bill Henderson's report there. And you and some others, I think, are working with the state of Utah on an initiative that will maybe put some of these ideas around lawyer regulation into practice on an experimental basis, as I understand it. What are you doing in Utah right now?
Yeah, so I'm actually excited about this Utah initiative. And I'll say this is very much motivated from the access to justice side. But the rules that are creating the problems on access to justice are the same ones that are causing the problems in the corporate sector. So I think there are benefits sort of across the entire spectrum in the legal sector available here. But
I assume if you're going to spark innovation, it's going to benefit everybody. It's
Yes, exactly. And in the corporate sector, there have been there's more capacity for workaround there. So the growth of the in-house legal department is partly a workaround on this. It says, well, instead of sending that work to outside law firms, we will pull it inside the corporation. So the largest corporations, and we know that this has been happening for over 10 years, they've been growing their in-house departments because they're not subject to those rules in the same way internally as the outside market. And then there's, using legal process outsourcing, and you can get some technology sold into that market, artificial intelligence and so on, because you're selling it to a lawyer and not to the general public. So we are seeing a bit of a workaround there. So it's in the personal services market and the access to justice side that it's saying this is where it's really, I think we have a real ethical obligation to be making these changes. And in Utah, I gave a talk at the conference of chief justices for the Western region about a year and a half ago, I think, and said, we can do this, and it just takes a consortium of state Supreme Courts to decide they want to build a regulatory system that can license providers other than lawyers, entities, organizations, corporations. They could be profit corporations, they could be nonprofit corporations and organizations. You need a structure in place to license those kinds of providers, and so that we're not just licensing lawyers and then leaving it to this set of rules. I think this has been the weakness in the challenge to the regulatory system has all been about change the rules of professional conduct, get rid of Rule 5.4, which prohibits fee sharing. And I think you really need to think about, what we need is a different kind of regulatory structure. And primarily, we need a regulatory structure that can license entities, can license organizations. So I got approached by a member of the Supreme Court in Utah, Justice Dino Himones, who was there and heard this, says, we are ready to go. We are ready to do this, and had the Bar Association on board. And I met with a relatively small group there to start talking about what this would look like. And we are sketching it out. We are sketching out a way to build a regulatory body that could license organizations, companies. And the plan is to open that up to something that's like a regulatory sandbox, which you may have heard about, say, in the financial services area. I don't think it'll exactly track the regulatory sandboxes that have been done in that area, but to say to companies and consumer organizations and legal aid entities and providers, come to Utah, tell us what it is you'd like to build, and we are going to create a regulatory environment for that that is outcomes-based and risk-based. So we're going to, basically following the model of how the UK does this regulation, which if you want to provide a service and you want to be licensed to provide that, do the risk analysis. Tell us what might go wrong. We will look at what we think might go wrong. And then to have a regulator that looks at that and says, okay, let's think about this. Here are some risks we've identified potentially with this service. Let's compare the world with that service and those risks to the world we're in now, which, remember, for most people, 90%, I think, is I'm doing it on my own or I've got nothing. And is there a way to, say, mitigate any of those risks and then take on some of those risks to provide those services? And I've been advocating that a key feature of this has to be, you need to be able to say to those entities that come in and start providing those services, we'll be taking a couple of years sort of piloting this regulatory approach to figure out how to do it. You'll be required to share data and participate in the process of determining what are the outcome variables and procedures that will work to make sure it's good for the public. But you're not going to hit the end of the 2-year period and then get told you have to go home. that there'll be a structure in place that will help to ensure that those providers can continue, because nobody invests in building something if they haven't got a decent horizon to recoup on that.
It's really exciting what they're doing in Utah. I was out about a year ago to speak to their the bar's board of governors. That's not what they call themselves, but their governing body, and about some of these issues around obstacles to use of technology and obstacles to innovation. They were extremely open and excited about the idea of bringing about some reforms, as you say, to tackle access to justice issues in that state in particular, but for broader reasons as well. So that's really exciting. I look forward to following what happens there. We're starting to run low on time. I wanted to, before we wrap up, ask you about some of your more recent research in the area of artificial intelligence, and something you've turned your attention to, and maybe you'd written about this before, but I know you've been writing about it more frequently lately. Is kind of the issue of protecting society from artificial intelligence, and ensuring that protections are in place so that it is safe. What are you looking at there? What are your concerns, and what are you looking at? How are you looking at addressing them?
So artificial intelligence is developing at a tremendous pace. If you look at and largely because of powerful machine learning, that, we sort of crossed over some important benchmarks around 2012 with, the capacity to develop systems that, made big leaps in image recognition and so on. And the pace at which this is developing is really quite impressive. There's artificial intelligence all around us now, in our phones and in our cars and in our courtrooms. Many U.S. courts are using machine learning systems to help decide on bail and sentencing. And it's proceeding at just a tremendous pace. And that's one of the things that makes me a little nervous, because it's a dramatic challenge to the ways in which we organize our human world. Machine learning is very powerful, but it's also very hard to understand what's going on inside the machine. That's partly what's making it so powerful. It's better than us at solving some problems, and that's what we're trying to build. And that's great, because better at diagnosing medical problems, better at figuring out how to, organize the transit system in a city, and so on. But because it's moving so fast, and because it's can be pretty inscrutable to understand what's going on inside the machines, there are risks of, will it continue to do what humans want it to do? We can test it when we're building it. How well is it at performing on a particular metric? Is it identifying tumors better than, on the set of images that we ask it to look at, better than humans with reasonable accuracy? But once you deploy it out into the world, is it going to continue to behave the way that it did in the lab effectively, in a different environment with different data, and so on? And so the real challenge is, how do we make sure that stuff works the way that we want to? And that's what brings us back to, basic legal infrastructure, basic rule infrastructure. How do we make sure that the algorithms are not discriminating? How do we make sure that we are not building something that puts a very powerful facial recognition technology into the wrong hands? There's concerns about autonomous weapons, of course. There are concerns about, privacy and the control of data. There's significant impacts on, the balance of power in society. So we're going to need for our rules, our legal systems to be able to regulate how is this powerful new technology being used. And that's when I come back to, okay, so how, what's my prediction about the likelihood that our legal systems are going to be good at responding to this really dramatic new challenge? And say, whoops, we haven't been responding very well so far. And we're going to need some tremendous levels of innovation in how we think about legal systems and rule systems in order to manage this new challenge. And so I think we need to act quickly to get innovative about those procedures. And so part of that is this regulatory story, and it's sort of the regulation of the legal markets. And another part is, and we need to rethink how we do regulation itself. Our existing models are not going to move fast enough or be smart enough, I think. So I think we need to be innovating kind of across the board.
Which of course goes back to your book, because developing regulatory markets is a major theme throughout your book as well, and that's part of the way that you see addressing these issues around AI.
Sure. So we've talked about the ways in which you need to free up markets to improve the capacity of your systems to figure out better solutions. That's the great beauty of markets. Now, I'm not a free marketeer. Markets need regulation, so it's not a free for all. But you want to figure out a way. How do you harness the creativity of markets? And I think this is what we're going to have to do in the regulatory area. So I've started working with colleagues at OpenAI to develop a prototype for something we're calling regulatory markets, which is, can we develop a framework for private providers, so for-profit organizations, to develop regulatory schemes that could address some of these challenges in AI, for example, and yet do so in a way that to political oversight. We have a system which says, okay, our political layer will come up with that, and then we'll set out a set of complicated rules. Think about the length of our 1,000-page healthcare statutes and our 2,000-page financial regulation statutes, and then just deploy that down to the actual actors. What we're trying to do is think, can we develop a model where we create an independent, competitive layer of providers of regulation who are required to get licenses and demonstrate to the political oversight layer that they're achieving the objectives set politically, but are developing the systems. So whether it's rule systems, technology, data exchange, and so on. So we're exploring the potential to develop that as a new model for how we could get a regulatory system that it can respond to the speed and complexity and global nature of the challenges facing in AI.
And just to be clear, you're not talking about having Google regulate the AI in self-driving cars. You're talking about having independent, private but independent regulators who essentially will compete in the marketplace for in order to maintain their ability to regulate in a particular area.
Right, exactly. In fact, part of the motivation for this is to say, right now we are looking to Google and to Facebook and to Amazon and our large corporations to regulate themselves in these domains to a significant extent, because government doesn't have the capacity, doesn't have the technological capacity, doesn't have the speed, can't respond fast enough. So a lot of that regulation is actually happening as a self-regulatory model. So this is saying, hey, Google shouldn't be regulating itself. Facebook shouldn't be regulating itself. But given that we can't actually get governments to do that in a detailed way, can we say, so say OpenAI has what's called an AI safety team internally. This is a group of engineers who are focused exclusively on building technology to make AI safer. So like if we could create this independent regulatory layer, an AI safety team like that could say spin off and become an independent AI Safety Inc. with a license to then regulate, for example, Google. And you say to Google, you need to find a licensed regulator in these different domains. So I work with a lot of really smart, terrific engineers, a lot of whom are quite concerned about how to make sure that AI is safe and beneficial. We have lots of people focusing on how do you make sure AI is non-discriminatory? How do you make sure our machine learning is fair? Okay, we develop all these techniques. How are we going to get them implemented? This is actually a procedure to say, no, don't rely on the corporations to impose these constraints on themselves. Create an independent layer of private regulators who have the incentives to invest in developing those technologies. Ensure that those regulators are demonstrating to the public that they're achieving outcomes that have been set by the public.
Well, Gillian Hadfield, I know that you have a flight to catch, and I wanted to thank you very much for taking the time to be with us on LawNext today. If you were sitting here in my office, you'd see that I have a dog-eared copy of your book sitting on my desk next to me. It's really a fascinating read, and it's been great of you to take some time to be with us today.
Great, thanks, Bob. I really enjoyed it.
Well, safe travels, and I look forward to following your next steps, and especially what's going on in Utah. So keep me posted. Good to talk to you.
I will, absolutely. Thanks a lot.
We've been talking with Gillian Hadfield, professor of law and economics at the University of Toronto and author of the book Rules for a Flat World: Why Humans Invented Law and How to Reinvent It for a Complex Global Economy. Thanks again to Gillian Hadfield for taking the time to be with us today.